Hello everyone, this is the 160 Literary and Jury Charge portion of the class. We're going to start off with some Latin and French words and then I will read you the paragraph. Ready? So we've got mala in se, nolo contendere, per curiam, and the last one is in flagranti delicto. Okay, and here is your paragraph. Ready? Mala in se translates to mean an act which is wrong in and of itself. Acts which are mala in se are wrongs that violate society's morals. A no contest plea is nolo contendere. Nolo contendere means I do not wish to contend. A per curiam opinion is rendered by the court. Per curiam is a method by which a court may render an opinion as a whole rather than through one specific judge. Mala in se includes robbery, rape, and murder. In a criminal action, nolo contendere means that the guilt is not admitted, although the punishment is accepted. In flagranti delicto literally means caught in the act of committing a crime. A person caught in flagranti delicto is caught red-handed. And let me spell these for you so you can put them in your dictionary after the class. Mala in se, M-A-L-A space I-N space S-E. Mala in se. Then we have nolo contendere. That's N-O-L-O space contendere, C-O-N-T-E-N-D-E-R-E. Nolo contendere. Then we have per curiam, P-E-R space curiam, C-U-R-I-A-M. I gave you mala in se. Let's see here. Oh, the last one. In flagranti delicto, I-N space F-L-A-G-R-A-N-T-E space delicto, D-E-L-I-C-T-O. All right. Again, you just write those phonetically. If you're not, if you've never heard of it before, you just write it phonetically and look it up later. Okay, so I've got a paragraph for you from Don't Sweat the Small Stuff. This is on Choose Your Battles Wisely. All right, here we go. Choose your battles wisely is a popular phrase in parenting, but is equally important in living in a contented life. It suggests that life is filled with opportunities to choose between making a big deal out of something or simply letting it go, realizing it doesn't really matter. If you choose your battles wisely, you'll be far more effective in winning those that are truly important. Certainly, there will be times when you will want or need to argue your case, confront, or even fight for something you believe in. Many people, however, argue, confront, and fight over practically anything, turning their lives into a series of battles over relatively small stuff. There is so much confrontation in living this type of life that you lose track of what is truly relevant. The tiniest disagreement or glitch in your plans can be made into a big deal if your goal, conscious or unconscious, is to have everything work out in your favor. In my book, this is nothing more than a prescription for unhappiness and frustration. The truth is, life is rarely exactly the way we want it to be, and other people often don't act as we would like them to. Moment to moment, there are aspects of life that we like and others that we don't. There are always going to be people who disagree with you, people who do things differently, and things that don't work out. If you fight against this principle of life, you'll spend most of your life fighting battles. A more peaceful way to live is to decide consciously which battles are worth fighting and which are better left alone. If your primary goal isn't to have everything work out perfectly, but instead to live a relatively stress-free life, you'll find that most battles pull you away from your most tranquil feelings. Is it really important that you prove to your spouse that you are right and she is wrong, or that you confront someone simply because it appears as though he or she has made a minor mistake? Does your preference of which restaurant or movie to go to matter enough to argue about it? Does a small scratch on your car really warrant a suit in a small claims court? Does the fact that your neighbor won't park his car on a different part of the street have to be discussed at your family dinner table? These and thousands of other small things are what many people spend their lives fighting about. Take a look at your own list. If it's like mine used to be, you might want to reevaluate your priorities. If you don't want to sweat the small stuff, it's critical that you choose your battles wisely. If you do, there will come a day when you'll rarely feel the need to do battle at all. Great advice. All right. Jury instructions. Let me give you a word list. You're going to hear circumstantial, sufficiency, influences, combination, existence, acceptable, necessity, susceptible, conclusion, dispassionately, objectively, entitled, interpretation, inference. All right. All right, here we go. I want to go over the instruction now as it pertains to direct and circumstantial evidence. The court will instruct you that direct evidence is evidence that directly proves a fact without the necessity of an inference, and which by itself, if found to be true, establishes that fact. Circumstantial evidence is evidence that, if found to be true, proves a fact from which an inference of the existence of another fact may be drawn. It is not necessary that facts be proved by direct evidence. They may be proved also by circumstantial evidence, or by a combination of direct evidence and circumstantial evidence. Both direct evidence and circumstantial evidence are acceptable as means of proof. Neither is entitled to any greater weight than the other. Most of you were questioned about your understanding of that principle and your agreement with it. I think you all felt that that was a rule that you could go with, or that you could follow the law if you were instructed that way. There is further instruction as to circumstantial evidence, and it relates to the sufficiency of the circumstantial evidence as to how we prove our case. The court will instruct you that a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only consistent with the theory that the defendant is guilty of the crime, but cannot be reconciled with any other rational conclusion. That's a requirement when we have only circumstantial evidence. Furthermore, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. There are parts I am leaving out. Also, if the circumstantial evidence as to any particular count is susceptible of two reasonable interpretations, one of which points to the defendant's guilt and the other to his innocence, it is your duty to adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. So therefore, based on all of the evidence, there are two reasonable interpretations. One points to guilt and one points to innocence. You must deal objectively and dispassionately with the evidence and keep in mind that guilt must be established beyond a reasonable doubt. And I didn't give you this brief, but beyond a reasonable doubt can be written either Y final RD or YARD. But if you use YARD, you have to flag the word yard. So you have a choice there. And then innocence is N final NS. Innocent is N final NT. All right. I have a paragraph here that focuses on a basic brief review. So these are all briefs you received in theory. We've got tonight, TONT, business, BIZ, business, advice, VIS, short I, and then advise, VIZ, together, TOGT, necessary, NEZ. Okay. All right, here's your paragraph. It is necessary that we get together tonight to discuss a necessary advertising program. Our business has been falling off, and it is necessary to seek advice from our business advisor. It is true that small businesses are having trouble everywhere, but it is necessary that we be advised as to what steps we can take now to prevent trouble later. Perhaps other small businesses would have done well to have someone advising them before they got into trouble. More advertising is not necessarily the answer. We must all pull together. Tonight we will discuss what our business office advises, and together we will decide what is the best advice. All right, and I'm going to read this one more time. That was just under 160. Okay, so I will read this right on at 160. Here we go. Ready? It is necessary that we get together tonight to discuss a necessary advertising program. Our business has been falling off, and it is necessary to seek advice from our business advisor. It is true that small businesses are having trouble everywhere, but it is necessary that we be advised as to what steps we can take now to prevent trouble later. Perhaps other small businesses would have done well to have someone advising them before they got into trouble. More advertising is not necessarily the answer. We must all pull together. Tonight we will discuss what our business office advises, and together we will decide what is the best advice. Okay. Got some medical here. This is on Heartline. The benefits of magnesium. Here we go. Ready? Evidence regarding the importance of magnesium for cardiovascular health continues to accumulate. 7 previous trials involving a total of 1,300 patients with suspected heart attack showed that magnesium supplements reduce the number of deaths. Now, a large study from England has confirmed this finding. When magnesium was given during the early hours after suspected heart attack, survival improved by 24% over the first 4 weeks. At the Royal Infirmary, 2,316 patients admitted to the coronary care unit were randomly assigned to receive either intravenous magnesium or a placebo. Heart attacks were ultimately diagnosed in 65% of the patients. After 28 days, the death rate was 10.3% among those receiving the placebo and 7.8% among those given magnesium. This difference indicates that magnesium might lower mortality by about 25 deaths per 1,000 patients treated. Moreover, magnesium therapy reduced the incidence of left ventricular failure, an important predictor of survival and long-term quality of life. The use of other drugs such as aspirin or clot-busting agents did not diminish magnesium's benefits, although in some cases the magnesium infusions caused side effects such as flushing of the skin or a slow heart rate. None of these problems were serious. Based on this study, magnesium may become routine therapy during heart attacks, especially since the benefits of magnesium infusion are about the same as those afforded by other heart attack medications, such as aspirin or beta blockers, but with less risk involved. Additional research will be needed to determine the mechanism responsible for magnesium's beneficial effects and how this mineral may interact with other proven therapies in order to target specific patient populations likely to be helped. Okay, we've got some legal opinion and arguments. Here we go. Ready? First, we have questions 1 through 7, and they are listed on page 24A and 26D of the Points and Authorities filed by Huntington Center in support of this motion. Again, it's pages 24A to 26D. This is of the Points and Authorities. All right, now shortly before the colloquy that appears on those pages of the Huntington Center's Points and Authorities, Mr. Penwell testified, and this is on page 32 of these depositions. I see these depositions have been lodged with the court and that they have or they will be negotiated with the branch offices for Coast and various other places, such as Walnut Creek, California, which is some 500 miles away, Diamond Bar out in the Pomona area, West Covina, San Gabriel Valley, and Long Beach. All right, I let counsel inquire into the fact that Mr. Penwell had conducted these negotiations for branch sites because I thought it had limited relevancy to the man's capabilities and his background and so forth and so on. Then counsel wanted to get into the negotiation of the terms and provisions of each of these leases, whether Coast engaged a broker and what they told the broker and what they instructed the broker. I submit, Your Honor, this is just too far afield. I mean, we could go on forever in these depositions on that basis. So I think questions 1 to 7 respecting the negotiation by Mr. Penwell of these other branch sites having nothing to do with Huntington Center or Huntington Beach or negotiations of other branch sites within 30 miles of Huntington Center. It is just, so much absurdity in context of this particular suit. All right, now let's go on to questions 8 through 55. It seems to me, Your Honor, these can be treated as one group. These appear at pages 27A to 27W of the Points and Authorities filed by Huntington Center, and then also question 60, which is on page 30A, I think belongs in this group too. Now, these are all deals, Your Honor, with the question of why Coast, in relocating its branch from Huntington Center to the Edinger Plaza location, chose to move to Edinger Plaza rather than to some alternative location. Now, among those things, there are a series of questions asked to which officers participated in the decision to use Edinger Plaza, why that site was chosen among various alternatives, Mr. Penwell's conversations with officers as to why that site was chosen. It has nothing to do, as I pointed out earlier, with my anti-competitive motivation, assuming that that can conceivably be an issue. But again, the fact is why they moved out of Huntington Center, and what rights that may give Huntington Center depends upon the interpretation of the lease and upon the application of the lease. And why then it chose to move out it chose location A rather than B, C, or D. It seems to me, again, if these questions are permitted to be asked of Mr. Powell or Mr. Penwell, excuse me, we're going to have 5 more rounds of these questions going on by the end of May. I think it is a useless kind of discovery. Okay, and that concludes our jury charge and literary for the 160 class. Have a great day.